Good morning, everybody. I think we're going to get started. We've got an empty chair that will be filled at some point here. So good morning and welcome to the 7th session of the Thomson Reuters Civic Engagement Seminar, This Land is Our Land. Our 6th session last Friday covered the First Amendment clauses on freedom of speech and the press, and it featured Minnesota Chief Justice Lori Gilday. Today we'll discuss another part of the First Amendment, separation of church and state. My name is Tom Layton. I'm a VP in Legal Editorial Operations, and I'll be introducing the program today. In 2017, we launched this multi-year CLE-accredited series about the Bill of Rights and civic engagement. The program examines how fundamental rights have been understood throughout our history. The series engages panelists and participants in robust discussion and analysis of constitutional law, the value of informed citizenry, and the importance of meaningful dialogue between the government and the governed. Now for just a little bit of housekeeping business on CLE. The program has been approved for 1.5 standard CLE credits in Minnesota. The event code is 254960. It's been approved for 1.5 standard CLE credits in Wisconsin as well. If you replied yes on the hub page for this event, you are registered. For Minnesota and Wisconsin lawyers, the event code and event title will be sufficient for your self-reporting. The certificate of attendance is for your records. This civic engagement series has been developed through the cooperation of a number of different entities here at Thomson Reuters: Corporate Affairs, Government Affairs, the Pro Bono Network, and the Office of the Executive Vice President of Operations. All panelists in the program work on a pro bono basis. I'd like to give a special thanks to Chung Wong on Rick King's staff. He's been a great driving and organizing force for the series, and I would have embarrassed him by thanking him here, but he's waiting for our other guests, so maybe we can embarrass him later in the program. If you're looking ahead, there are a few additional programs that we've got prepared for 2018. The next session will be on a really timely and important issue, the Second Amendment, so you're not going to want to miss that. Other programs in the works are on voting rights, the Fourth Amendment, and the Fifth Amendment. Look for additional information soon, and please check the Hub event page for those details. So as I mentioned earlier, our session today is going to see an overview of separation of church and state, the Establishment Clause, and the Free Exercise Clause. So let's meet our panelists and our moderator. We'll do some quick introductions. I'm going to start with Justice Chris Dietzen. Justice Dietzen was most recently an Associate Justice of the Minnesota Supreme Court from 2008 until his retirement in 2016. Prior to that, he had been a judge on the Minnesota Court of Appeals from 2004 to 2008. Justice Dietzen graduated from Gonzaga University, both undergraduate and law school. I know they've had some questions lately about pronunciation of Gonzaga that have gone because of the basketball team, but I think I got it right okay, didn't I? No. We'll talk about it after. After law school, he practiced for a firm in Spokane, Washington for 5 years before he saw the light and moved to Minnesota, where he worked for Larkin, Hoffman, Daly, and Lindgren from 1978 to 2004. He also served as an attorney, or as the attorney, for Tim Pawlenty during his 2002 gubernatorial campaign. Our next panelist is Teresa Collette, and she would be seated next to Justice Dietzen there. She's a professor at the University of St. Thomas Law School. She received her Juris Doctorate degree at the University of Oklahoma College of Law. She specializes in the subjects of marriage, religion, and bioethics in her research. She's published numerous legal articles and is the co-author of a casebook on professional responsibility. She's an elected member of the prestigious American Law Institute, has testified before committees of the U.S. Senate and House of Representatives, as well as before legislative committees in several states. Now, our next panelist is Jason Adkins. Jason is Executive Director of the Minnesota Catholic Conference, a position he has held since 2011. Prior to that, he was an attorney for the Institute of Justice, a public interest law firm. Jason has clerked for appellate judges in both state and federal courts. He received his law degree from the University of Minnesota, where he has also served as an adjunct professor. Jason teaches at the St. Paul Seminary and writes a regular column that appears in diocesan newspapers around Minnesota. His writing has also appeared in numerous publications and journals. He's a frequent guest on radio and TV. And our moderator for today is Rick King. Now, if you don't know Rick, we're going to need to check you for a pulse, because Rick is everywhere, and he plays such an important role in everything we do here in Eagan. I'm sure all of you know him, but I'll quickly run through his impressive bio. Rick is Executive Vice President for Operations at Thomson Reuters. He's been with the company since the year 2000 and has held numerous executive-level titles since then. Rick is also very involved in the community. In 2011, Governor Mark Dayton appointed him to serve on the Metropolitan Airports Commission, and also the same year appointed him to serve on the Governor's Technology Advisory Council. In addition, Rick is recognized as an expert on broadband and was named by former Governor Tim Pawlenty to chair Minnesota's Ultra-High-Speed Broadband Task Force. He serves on the Board of Trustees for Minnesota Public Radio and the Minneapolis Institute of Arts. He also serves on the Board of Directors for TCF Financial Corporation and chairs its Technology Committee. He's received many awards and honors for his work both at TR and in the community. So please welcome all of our panelists and our moderator.
Well, thank you. Welcome. Glad to have you here for this exciting piece. So I would say seldom can so much be said about something so little in terms of the number of words that are important. So let's just start out with what we're talking about here. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press, which we did last week, or the rights of the people to peaceably assemble and to petition the government for a redress of grievances. Seems plain and simple, isn't it? Well, maybe not. But Justice, maybe the one thing I wanted to start with from your angle is that's the federal, that's the Constitution. What's the state Constitution? How does that resemble or differ from the federal Constitution in this area?
Well, it differs in several respects. Let me dig here for just a minute so I don't...
I kind of threw them a curveball. We were going to originally make some remarks, and I said I'd rather have it free-flowing and ask some questions. And so there might be a little looking at some notes and things like that, which I have to do. Because
see, when I was sitting all those years behind the bench, you didn't see...
Judge, is your mic on, by the way?
Is mine? No?
Maybe go to is the green light on?
Oh, is it on? Okay,
there
now, yeah.
Excellent.
Well, you didn't see when I was on the bench me shuffling papers, but I always do. Maybe a nervous habit. But when I knew that I was going to be asked a little bit about the state constitution, and there's a case that was decided by our court in 1990 called Hershberger that was one of my favorite cases. This separation of church-state doesn't appear anywhere in the federal constitution or the state, by the way, if you look at the words. But what Minnesota had was a case involving Amish defendants who, does anyone remember this case? They wanted to, the state wanted to charge them for a crime because they didn't use an SMV, one of those big caution signs on their buggies. And so they wanted to use a red lantern and some fluorescent tape. And in that case, it went to our court. Our court said that it was unconstitutional to require them to put that big sign on the back. U.S. Supreme Court reversed, remanded, sent it back. Our court looked at it again and applied the state constitution and said the language of our state constitution is more restrictive in terms of religious liberty in favor of the individual than the federal. So we then applied that law, our state constitution, and held in favor of the Amish and said, if it is a sincerely held religious belief, then the state has to show a compelling reason for, in this case, the public safety law. And they didn't, and so it was struck down, and the Amish were not required to put that big sign on the back, and now they have a red lantern and fluorescent tape. So I thought it was a fun case because, I mean, Amish are not people that I see in my normal life, but I respect the fact that they have a sincerely held religious belief, and it was an important constitutional issue for our state. If you're looking for some flowery language, Peter Popovich was then the Chief Justice, and he goes on and on about how important religious freedom is to individuals in Minnesota. And I knew Peter Popovich, and I could just hear him saying those words. And John Simonette wrote a concurrence where he said, "Let me add a few more flowery sentences," and he did as well.
Fascinating. Yeah, please.
Yeah, and it's that Hershberger case that Justice Dissent mentions important because Minnesota was the first state to provide greater protection under its state constitution for religious liberty after the notorious Employment Division versus Smith case, interestingly just decided by Justice Scalia, in which the court essentially said that laws that are generally applicable, even if they have an impact on religion, receive only rational basis review. So it lowered the Supreme Court's test for laws that burden religion from strict scrutiny to rational basis review. Many state courts rejected that and provide greater protection under their state constitutions, Minnesota being the first, precisely because of that value for religious liberty.
Excellent. I was going to ask you, Jason, about the Blaine Amendment. Now, this is kind of a classic treatment. I think we have maybe 37 or 38 states that
37.
37 that have a Blaine Amendment type piece to their constitution. But can you tell us a little bit about the history of that and what that's meant to this whole argument here?
Sure. So the Blaine Amendment's coming in, for folks who aren't familiar, that's coming a little out of left field in terms of the discussion, but
What's the Blaine Amendment?
Yeah, what is a Blaine Amendment exactly? Well, it's named after the same person who is Blaine, Minnesota. Blaine, Minnesota is named after a Speaker of the House, former Representative James G. Blaine of Maine, who in the 1870s as Speaker took the advice and the exhortation of President Ulysses S. Grant and proposed a constitutional amendment that would ban aid to quote-unquote sectarian schools. Now, in the time, this was code for anti-Catholicism. There's a wave of anti-Catholic sentiment. There was a big debate brewing in the nation because this is the rise of public schools in the United States, a system of public education. But public schools in the 19th century weren't secular schools, they were Protestant schools, right? So if governments were funding Protestant education for the masses, the Catholic schools said, well, the church said, well, we should get money for our schools too. Well, this set off a wave of anti-Catholic sentiment, which had been, sort of a constant thing in ebbs and flows throughout the 19th century. But these amendments were proposed to prevent sectarian aid to going to quote-unquote sectarian schools. So the Blaine Amendment was proposed. It didn't pass at the federal level, but a number of states, 37 of which, passed a Blaine Amendment in some form. Now, some states interpret that Blaine Amendment broadly to exclude various forms of aid to religious entities or religious schools. Some states like Minnesota construe their Blaine Amendment very narrowly. Therefore, we have things like the PSEO, post-secondary educational options proposal, in which you can go to, as a high school student, you can go to public schools for college or private schools for college. So we have things like that that have narrowed the construction of the Blaine Amendment here in Minnesota. But really, the Blaine Amendment is a vestige of anti-Catholic discrimination, and now it's a tool to prevent religious entities from participating in public benefits programs, and that's what the Trinity Lutheran case was all about.
I was just going to ask about the Trinity Lutheran case because that was just last year, I think
Right.
A year ago, almost precisely in April, decided, and it did kind of put a twist on that interpretation of the Blaine Amendment. Comments?
Yes. So I think the question you have to ask yourself, why was Trinity Lutheran important? It's just about playground, asphalt on a playground.
Putting ground up rubber tires in
That's right.
safety.
Yeah,
of the
an
playground.
environmentally safe thing to do. Well,
So it's the DNR of the state,
that's
really.
right. Yeah, so the Missouri DNR had a program, and the program was that if anyone could apply, and if you wanted to participate in the program, you could qualify for a grant. And the Trinity Lutheran Child Care Center, which was owned by the Trinity Lutheran Church, applied to replace their pea gravel surface with this rubberized asphalt. And they were denied that application, even though they were one of the top applicants. And the state of Missouri said, they admitted, the DNR admitted that churches were disqualified from receiving grants. So from a plaintiff's lawyer standpoint, this was like the perfect setup. And it went to the federal district court, and the Eighth Circuit, Judge Locke wrote for it was a split decision, and it was on a First Amendment issue, and it went to the U.S. Supreme Court case. Well, before I get to the opinion, I know you're hanging on this. Well, no, I'll tell you. So I'm going to just read it because I don't want to screw this up. So the issue was whether an otherwise eligible organization may be excluded from a grant program to replace a preschool playground surface. This is that pea gravel that Rick talked about, where the only reason for the exclusion is that the organization is a church. The court held that when a state awards grants on a religiously neutral criteria to create safer playground surfaces, it cannot exclude an otherwise eligible playground simply because it's church-owned. Such discrimination violates the free exercise and establishment clauses. Now, there was a strong dissent, and I'll get to that for a minute, but let me just pause and say, why was this case significant, which is getting back to what I think Rick was asking. And Professor Richard Garnett, I think, discussed this in a way that I think is important. He identified three features of the historical context of the case that are worth mentioning.
The lights are low, so don't worry about yourself.
I don't know. I was getting kind of excited here for a second. I knew it couldn't be right. So first, the Courts Doctrine having to do with government support for and funding of religious institutions and activities has evolved gradually but significantly since the late 70s. That's important to remember. The justices in Lemon versus Kurtzman, how many can remember that case? Raise your hands. Well, a lot of you can know that case. And the Nyquist cases embraced and attempted to apply a rule of fairly strict no-aid separationism, according to which policies that had the principal or primary effect of advancing a religion were unconstitutional establishments of religion. Over time, the court's focus shifted from the possibility of advancement to a requirement of government even-handedness or neutrality. Now, that line of cases goes back to Zeman, which was decided in 2002, where the U.S. Supreme Court applied equal treatment is not establishment. And that's where the court is going, and I think this case, Trinity Lutheran, is a clear step in that direction. This sort of neutrality is the constitutional touchstone, not the advancement of religion. The third feature, I think, is what Jason and Rick talked about earlier, the so-called Blaine Amendments. That's the historical context, and in Trinity Lutheran, what the court did was review its precedent. And I'm looking at this as from the perspective of a justice, and the first thing I look at when I look at an opinion is what's the starting point of the analysis? Well, they didn't start with Lemon v. Kurtzman. They started with three cases that talked about neutrality. And these are kind of cool cases, I think. Everson, McDaniel, and Church of Lukumi. So in Everson, which was a 1947 case, the court upheld a New Jersey law enabling a school district to reimburse parents for public transportation costs to sending their children to public and private schools, including parochial schools. The court concluded a state cannot hamper its citizens in the, quote, free exercise of religion. Consequently, it cannot exclude Catholics, Lutherans, et cetera, or members of any other faith because of their faith or lack thereof from receiving the benefits of public welfare legislation. Now that's one sentence. Now there was an earlier sentence in Everson that the court didn't discuss, but that sentence became the touchstone of the dissent. The dissenter's point of view was you can't establish a religion, and we'll get to that in a minute. But then the majority also talked about the McDaniel case, which was a Tennessee statute disqualifying ministers from serving as delegates to a constitution convention, said it was unconstitutional, reasoning that it expressly discriminated against McDaniel, who wanted to be a constitutional delegate but happened to be a minister. The court said that violated his liberties. And then my all-time favorite case, Church of Lucuma, where the court struck down 3 facially neutral city ordinances that outlawed certain forms of animal slaughter. I mean, this is like slitting their throat kind of slaughter. And the citizens' neighbors said, this is disgusting. This is awful. It's got to be against the law. And so they made a law, and it went to the U.S. Supreme Court, and they said, no, you cannot discriminate against religion. Even though it's distasteful to local residents. I don't know if they were what they meant by distasteful, but no pun there. But they restated their prior statement that the free exercise clause protects against laws that impose special disabilities on the basis of religious status. Then what happens? The state of Missouri, guess what they say? You can just hear it. However, merely declining to extend funds to Trinity Lutheran does not prohibit the church from engaging in any religious conduct or otherwise exercising its religious rights. So how can it be unconstitutional? And the court said, well, you're right, it didn't criminalize them, what they were doing, like you had in Lukumi. They were criminalizing the animal slaughter. But it also, the First Amendment also protects against coercion, indirect coercion, or penalties. And here, Trinity Lutheran asserts the right to participate in a government program without having to disavow its religious character. And the court goes on to say the imposition of such a condition will deter or discourage the exercise of its First Amendment's right, and therefore it must be held to the strictest of scrutiny. The most difficult part of the case to me, because I've sat in this chair, is how did they distinguish Locke v. Devi? Is anyone here familiar with Locke v. Devi? So Locke v. Devi is a Washington State case. And Washington State had this law which allowed, provided scholarships to high-achieving students for the cost of post-secondary education, so a very laudable goal. The scholarships were paid out of the general fund. Eligibility was based on objective criteria like college admission test scores, family income. They were scholarships the recipients were free to use the money at any accredited religion and non-religious schools, but not permitted to use the funds to pursue, and this was under the state constitution, this language, a devotional theology degree, devotional in the nature designed to induce religious faith. When Devi was denied the fund, he sued. The federal district court rejected the claim. The Ninth Circuit reversed, said that it was unconstitutional. Supreme Court reversed and said, no, it's not. And they went by talking about this leukemia line of cases and said, hey, we're not talking about criminal law here. We're talking about whether the state has the right to not fund someone who was going to pursue a devotional theology degree. And the U.S. Supreme Court said that was different. And they had, I think, some important language there that sort of frames the analysis. They said here, or in Devi, Devi was not denied a scholarship because of who he was. Instead, he was denied a scholarship because of what he proposed to do. He wanted to use the money to pursue this degree, right? Here, Trinity Lutheran was denied a benefit simply because of what it is, a church. That's all they were distinguishing, church. And the court said that is different. And then they said, further in Locke, Washington State's choice was in keeping with its anti-establishment interest, kind of the Blaine Amendment sort of issue, in not using taxpayers' funds to pay for the training of clergy. In Trinity Lutheran, nothing of the sort can be said about a program to use recycled tires to resurface playgrounds. Using money to pay for clergy is a whole lot different than using money to pay for playground surfaces. And so in that manner, the court distinguished Locke. And I think that is when you read the case, the other thing that becomes really, I think, kind of exciting about it to me is that when you distinguish something, the people that read it just hang on every single word. And there's some language in the opinion that the case was, they could interpret Locke in a narrow way, that it was only about what law to apply when deciding whether you had to pay for clergy, or is it more broadly, Locke more broadly apply to anything. And there's language to support both. Do you interpret Locke narrowly, or do you interpret it broadly? And that became kind of a fight between the majority and the dissent. The majority was interpreting Locke broadly, but they put a little footnote in it, and the footnote's kind of exciting. I'll talk about that later. I don't want to hog all the time here, but the other thing that was interesting to me about the case is that Gorsuch and Thomas filed concurring opinions, adopting everything except for the footnote 3 that was in the majority opinion. So the dueling views on footnote 3 came in, and the dissenters, Sotomayor, and joined by Justice Ruth Bader Ginsburg, went on the, they had I would best describe it, I think, as a vigorous, it was a really passionate dissent, where they took the position that, remember that case I started talking about earlier, Everson in 1947, the school bus case, funding for school bus? The majority quoted one sentence from Everson. The dissent quoted the other sentence in the prior paragraph in Everson to support their position. So they were fighting over language in this 1947 opinion. Very exciting, I think.
There we go. Please.
There's also an important concurrence from Justice Breyer, though, picking up on your point about Justice Sotomayor's dissent. And I think he, on that heated dissent, I think he pours a glass of cold water on it. Here's why. He references the Everson decision. Remember, the Everson decision was written by Justice Hugo Black, former member of the KKK, vigorous anti-Catholic, eager to erect that wall of separation and infuse that in the Supreme Court's jurisprudence. But yet, the court in Everson upheld a busing program that allowed children attending parochial schools to receive busing aid. That's what's forgotten, is that actually upheld that funding grant. Breyer says that Trinity Lutheran is essentially the same case. So what Sotomayor does and Ruth Bader Ginsburg is they want to go above and beyond what the Establishment Clause forbids and allow states to not erect a wall of separation, but in my mind, a wall of exclusion for religious entities from participating in public programs. They're really the torchbearers of James G. Blaine and the know-nothings of the 19th century in many ways, and trying to fence off religion from participation in some of these important public programs. But Breyer notes that really the Everson case, in which the wall of separation was erected in the jurisprudence, is functionally the same case as Trinity Lutheran. So what Sotomayor and Ruth Bader Ginsburg want to do is to go above and beyond that, allow states to continue to go beyond the Establishment Clause, because remember, Blaine Amendments, which is the vehicle, they forbid what the Establishment Clause allows, right? So this is states going above and beyond it, not just erecting a wall of separation, but when it comes to these public welfare programs, a wall of exclusion. So if you read the tea leaves going forward and what Trinity Lutheran really means, is that you have a 7-member majority of the court who in some way sees these Blaine amendments as somewhat discriminatory and are skeptical of state-based regulations that exclude religion from public funding programs. 7-2 majority, I think that's really the big takeaway here. There might be some play in the joints, to use a term, about how broadly they're willing to allow those exclusions. School choice programs, which we may talk about, might be upheld by some of those justices and struck down by others. But broadly speaking, you've got a good 7-member block on the court that's going to look very skeptically at state-based efforts at excluding religious entities from these public welfare programs.
So I don't completely agree with Jason on this point, but I do, I'm not sure where the court's going to go, but here's where I think I agree with most of what he says, and it's premised on this. So in Everson, which is the school funding of transportation, they quote 2 sentences in that opinion. One is, no tax in any amount, large or small, can be levied to support any religious activity or institution, whatever they may be called, or whatever form they may adopt, to teach or practice religion. So consider the absolutes in that sentence. No tax, any amount, any religious activities, whatever form. That's the language the dissenters were relying on, saying, hey, you can't do this. This decision goes the other direction. And the majority relies on the other language of Everson in that next paragraph that I quoted earlier. A state cannot hamper its citizens in the free exercise of their religion. Consequently, it can't exclude Catholics, Lutherans, Baptists, Jews, etc., because of their faith or lack thereof, from receiving the benefits of public welfare legislation. Those 2 sentences contradict each other on the extremes. And that, to me, is what the court's been fighting about for the last 70 years. And let me introduce Professor Teresa Collette.
Welcome.
I'm so embarrassed. Thank you. I am living proof that there is some truth in some stereotypes. The absent-minded professor has arrived. So,
Well, we're glad you're here. Welcome.
thank you.
We've just been warming up a bit, but we'll let you get settled here. A lot of discussion about different cases and the Trinity Lutheran case and those types of things. Would maybe and we talked about the federal and state protections here earlier. But if you'd like to make any comments about any of those things or the Trinity Lutheran case, you'd be jumping right into the fray.
Well, my original task, which I'm too late to do now, is to set the scene. So, but I had focused my reading this morning just to refresh my memory on the separation of church and state doctrine. And what I find really interesting is that phrase, of course, as all of you know, doesn't appear anywhere in the text of the Constitution or the amendments. It's a phrase that was taken from Jefferson's letter. Forgive me if I'm covering what you've already covered. Jefferson's letter to Danbury Baptist congregation, who was concerned about the fact that there was a debate about the establishment of religion at the state level. Now, when the Constitution was enacted and the Bill of Rights passed, there were 6 out of the 13 states that actually had established churches, meaning that the tax money went to the churches. They supported the establishment of religion. And when you read both the Federalist Papers and the Anti-Federalist Papers, it's pretty clear that all of the Founding Fathers thought that religion had some merit in creating a society. They reenacted, for example, a number of actions. And George Washington, who was our first president, of course, his first official act was to invoke the blessings of God on this great enterprise. And in his farewell address, he also talked about that we are a religious people, and without religion and morality, we don't have much hope of making it as a country. So I think the scholars to date, whether they like the outcome or not, are pretty clear that the federal provision regarding the government shall make no establishment of religion was about protecting those 6 states that had established religions. It wasn't intended to reach state government. Now, of course, we all know in the Everson opinion, the court embraced the phrase separation of church and state after answering the question, should we even incorporate this to the states? Now, that's a whole separate, question. I don't know. I suspect we might have unanimity on the table, panel. I think the Slaughterhouse case was wrongly decided. Good Lord, what's Slaughterhouse, Professor? I'm a copyright lawyer. But the Slaughterhouse case, if you remember, was when the court was asked the question, how do we interpret the 14th Amendment? Does it create essentially a set of independent rights that are based on your federal citizenship, which would have been a more direct overturning of the Dred Scott case, which is what it was enacted to do. Would it have been, or does it in fact do something different? And the court said no, that the rights are derived from the Bill of Rights in a separate way. So instead, what they had to do to pick up those Bill of Rights is to incorporate them through the 14th Amendment. They said that's what it does. And they did that in a religion case. That was what's so odd about that, particularly given the method they chose, because not all of the Bill of Rights has been incorporated yet, which is an interesting point that only con law geeks know. But what's interesting about it is they started with the Establishment Clause, which was drafted as evidence, and again, I know of no historian that now dissents on this, specifically to allow the states to do their own thing. So how is it that this particular provision that had at least an attenuated relationship with the slavery question was where they chose to start applying the federal Bill of Rights to states? Unless you think, oh my gosh, this woman doesn't believe in any rights at all. Not at all. But the original structure, if you remember, was that every state had its own state constitution. And those state constitutions can be stronger than the federal constitution. And in fact, in the areas of free exercise, perhaps Justice Deason and Jason have already mentioned this, we have a stronger protection through the free exercise clause here in the state constitution than we do the federal level. I was telling my students, we were talking about Kelo, the takings case, where the U.S. Supreme Court agreed that government can take your property through eminent domain in order to pass it on to a corporation that will reinvigorate or redevelop a part of an urban area. And I said, the reaction was over 30 states immediately said, well, not in our state, not our state government. So there is some independence of state constitutions. But in the Establishment Clause, because they incorporated it, we don't have that sort of independence to decide what protections we think are appropriate given our cultural and social setting.
Fantastic.
Thank you.
Glad to have you here.
Well, I'm delighted and embarrassed at one level to be here.
Okay, that's done.
Okay, thank
You don't
you.
have to say
Yes.
that again.
All right.
We're all just happy you're here.
Thank you.
I think that we had some good discussion around the general point. I think, what's the impact of these kind of the Trinity decision on the current thinking? We started getting into that a little bit about what the court's thinking and what's the next direction here, and then how does it impact programs that are in the public domain today, like school choice, voucher programs, things like that. I'll just, Jason, maybe I start with you, but give everybody a chance to chip in here.
I was going to start talking about school choice and thinking about that question, sort of the broader implications, but I actually want to start with a couple of building-related cases, because I think those are kind of interesting as well. Shortly after Trinity Lutheran was decided, actually it was in January of this year, the Federal Emergency Management Agency, FEMA, backed off on a 20-year rule that forbade churches and houses of worship from receiving aid from disaster relief, right? So after Hurricane Harvey in Houston, churches, mosques, synagogues on the front lines of disaster relief serving their communities. Everyone praises that, but yet FEMA excluded those houses of worship from receiving aid to rebuild and help restore those very communities that were providing social capital in the wake of that hurricane. The Becket Fund for Religious Liberty had been challenging that rule for some time. After the case went up to the Supreme Court and briefing had started, FEMA backed off, changed its rule, allowed money to flow to houses of worship for disaster relief grants, and then Congress subsequently changed the law as well. One instance of Trinity Lutheran having an impact is now houses of worship themselves are getting funding for disaster relief. A second interesting case, it's right now in front of the New Jersey Supreme Court, involves preservation grants. A case whether or not if a legislature provides grant funding for preserve historic college buildings. And New Jersey actually has very beautiful historic colleges, despite it being New Jersey. Princeton.
There are lots of beautiful places.
There are. It's in the Garden State, exactly. But Princeton being one. And so the question is that can the Chris Christie administration give out preservation grants to a Jewish yeshiva, a school for rabbinical studies, Princeton Theological Seminary, religious schools? Can they receive those preservation grants? That case is in front of the New Jersey Supreme Court right now. It's been heard, has not been decided. It will be interesting to see how they interpret their Blaine Amendment as to whether or not their Blaine Amendment is going to override the free exercise values and direction given to us by the U.S. Supreme Court. So again, as Justice Dissent was saying, that tension between state anti-establishment principles in their Blaine amendments, at the same time, the federal free exercise values that Trinity Lutheran embodies as well. A couple other contexts are textbook funding. We have programs here in Minnesota, non-public pupil aid. Regardless of which school you attend, all students, or if you're homeschooled, all students receive various forms of public funding. Busing, counseling services, textbook aid, et cetera, et cetera. If the state decided, for example, that only school students who attended non-sectarian or non-religious private schools or homeschooled could receive those, but not students attending religious schools, would that be upheld after Trinity Lutheran? Probably not. In fact, after Trinity Lutheran, there's a similar case out of New Mexico where a textbook aid program that had been around since 1930 was challenged on this basis on the state's Blaine Amendment. That case went in front of the New Mexico Supreme Court, which struck down the grant of aid to students attending religious schools. That decision was vacated and then remanded back to the New Mexico Supreme Court, where it's still pending further outcome. So the big issue, though, that people are watching, what's the big implication of this? Because it involves that tension between federal free exercise and the ongoing legitimacy of Blaine amendments. Are they protecting core values of a state to disestablish religion, or is it the functional equivalent of discrimination? We know, as the Supreme Court itself had said, these amendments were born in bigotry and have always been applied in a discriminatory fashion. the mandated reading of the King James Bible in public schools in Minnesota was upheld, even under, even with the Blaine Amendment here. That's definitely a sectarian version of the Bible, yet that was allowed still. So it's still applied in a discriminatory fashion. The question, though, is can school choice programs that allow aid to go to parents who then choose non-public schools with those vouchers, education savings accounts, tax credits, et cetera, can those be challenged after Trinity Lutheran based on a state's Blaine Amendment? And I think it's really an open question. What we do know is that after Trinity Lutheran, a very important case out of Douglas County, Colorado, which is sort of right in between Denver and Colorado Springs, which a county had created its own school choice program. It had been struck down by the Colorado Supreme Court and then taken up to the U.S. Supreme Court, which again, after Trinity Lutheran, vacated and remanded for further consideration in light of Trinity Lutheran. Many people read this as, oh, no, actually, it is pretty clear that the principle that we've enunciated here, despite this footnote 3, which seems to narrow the opinion, it in fact does apply. And the reading the tea leaves, people thought that in fact the Colorado Supreme Court would reverse and then uphold the program. Now, interestingly, the political dynamics of the Douglas County School Board changed, and fearing that in fact the court would uphold the program, they politically ended the program. So it's really kind of an open question now after Trinity Lutheran, what's the ability states will have through their Blaine Amendment to strike down legislatively created school choice programs. Really interesting question.
I wanted to come back to one point. Just as I recall, and I was trying to look through my notes, I don't think New Jersey has a Blaine Amendment, do they? I think they're one of the
I don't have the
states
map in
without.
front of me. They have some provision in their constitution,
Do they?
though.
Okay.
Yeah.
A lot of people say that this, the Trinity Lutheran decision was very narrow. That makes it sound like it could be quite broad.
Well, that's sort of the point in Justice Gorsuch's concurrence, is that, you know, Chief Justice Roberts, we have to give him credit where credit's due. He's a master judicial craftsman and judicial politician along the likes of Justice William Brennan. But cobbling together 7-vote majorities and putting in these decisions really principles that, despite maybe some narrowing constructions, the logic of which is sort of inescapable. And that's really Justice Gorsuch's point is, yes, this principle of anti-discrimination against religion definitely applies on the playground, but it also applies everywhere else too. And I think the logic of the opinion is going to make that difficult for all sorts of funding programs going forward. Maybe not school choice because of the politically charged nature of that question, but like I was arguing earlier, and maybe Justice Dietzen agrees, I think in a lot of these public welfare programs or public benefit programs, state-based exclusion of religion, that's going to be a tough sell with federal courts.
My perspective is limited because I'm a working justice on the Supreme Court, so I can't take positions, political positions.
We always hear this from all of you guys.
But I get to hear what my colleagues have to say, who are doing a wonderful job. Well, what we can say is that Everson's non-discrimination principle, the dueling sentences that I read to you earlier, was the one that was relied upon by the majority in Trinity Lutheran, and that has increasingly come to dominate the court's prior no-aid principle that you saw in Lemon v. Kurtzman and the other cases. When a state awards grants on religiously neutral criteria to create safe playground surfaces, it cannot exclude an otherwise eligible playground simply because it's church-owned. 7 members of the court, and I think this is a little more direct, ruled that the U.S. Constitution requires the disbursement of public welfare funds by the government to a church for its school. I don't think that has been as explicit. The limitation of the opinion, which I think Jason got to earlier, is it depends on how you count the noses, and you can kind of make some predictions about the justices, but footnote 3 provides some support for a narrower reading of the majority opinion in Trinity Lutheran, and of course, depending on your perspective, that's the one you want to give it. Others will give it a more, a broader reading, but footnote 3 limits the scope of the court's opinion to express discrimination based on religious identity. You know, you can't discriminate against a church. They did. Therefore, it's unconstitutional. And it was with respect to playground resurfacing. The court reserved religious uses of funding or other forms of discrimination to a later day. And I think that that is still up in the air, but based on how you count noses, you can make some pretty good predictions about what's going on or what will go on here. But I think we're seeing kind of an evolution or a revolution, depending on your perspective.
Professor, I'm going to come to you in a second, but I want to give the warning that we're going to ask questions. So get those brain cells stirring, and we'll come back to you in just a minute.
So let me give you an example that will actually, that's past, it's a historical example, but would put that footnote 3 directly at issue before the court. I was born and raised in Oklahoma. And as we know, it was, Oklahoma City was the site of one of the most costly domestic terrorism incidents with the Oklahoma City bombing of the federal courthouse. Literally 2 blocks away from that courthouse and at least deeply damaged were a number of churches, including the oldest Catholic church in the state. And at that time, FEMA had in place the position that Jason mentioned. And even though they were reconstructing buildings or helping repair buildings all around the perimeter of the federal courthouse, the churches were told that this was not going to be available to them. And so if we were to have, God forbid, a similar disaster, right, there's not much argument that you can make that we need to use federal assistance to replace the altar of St. Joseph's Catholic Church for a secular purpose. And so in that instance, you might end up with sort of finessing the question by saying, we can help you rebuild your community hall since that's where you do your homeless housing, as many of the Catholic churches do here in town, but anything you're going to use in the worship center, in the actual church part of the building, you know, you're precluded from doing that. We see a lot of that now anyway. When the University of St. Thomas built the law school, they accepted some public funding. And so, oddly enough, we have no crucifixes in the school, at the law school. Now, of course, we have them in other places because we hadn't taken any money to build those places. But that's an exceptionally odd place where when we're talking about whether we can accept certain pieces of art or not, we've got, you know, huge paintings of donors. That gives kind of an odd message if there are no other symbols in the building. But that would be an example that would put to the point, because as Jason describes some of the initial concerns, these were natural disasters where the churches were being used for, if you will, services that are afforded equally by secular groups as well as by religious groups. But with the Oklahoma City bombing, there certainly were places that were destroyed or deeply damaged that were not used. They were used for worship. They were worship centers. How would footnote 3 come out? I think that's the sort of case that's really going to provoke this question.
You raise another question in my mind, Professor. When I was on the court, we have chambers which are available to the public, and I had in my chambers a gift that had been given to me by a friend when I was sworn in, which was a Russian icon of the Blessed Virgin and the Christ child. And someone came up to me once and said, I don't think you can have that in here. That's a religious symbol. And I said, well, I also think it's a piece of art. And that was the end of the conversation.
There actually are judicial ethics opinions on this very point.
I hope the statute of limitations.
I hope you're in the clear, yeah. I hope you're going to be okay on this.
Oh, God.
And you're on the right side of the law.
Oh, we knew that.
If you had, in fact, yes, I wouldn't have mentioned it otherwise. But the cases come up. There are some states and some counties, perhaps even in this state, where a judge might bring a Bible and place it on their bench in the public courtroom. Those are the ones that cross the line. But when it is in their chambers, that is used primarily as a private area for their work, notwithstanding public access to it.
Right,
The ethics committees have been much more forgiving on that. So,
Good questions. Yes.
I have a question about the textbook funding. Textbooks, there's funding for textbooks across all schools, but is there a limitation as to what type of textbooks? Is it secular textbooks only, or can it also fund religious textbooks?
It cannot fund religious textbooks, history textbooks, geography, math, science.
Thank you.
Up to the front. I guess we got to wait for our microphone. How are we feeling? Athletic today, right? Okay.
I've never seen
It's the opening day of the Twins.
My question is just, what is the intersection between the Establishment Clause of the First Amendment and taxation status of religious institutions? Does tax-exempt status, is that something that's derived from the Establishment Clause, or is that something that's kind of a separate part of the tax law?
it actually was based on the political judgment that churches provide social capital, to use Jason's phrase, or fulfill a number of socially beneficial areas. So churches have tax-exempt status, as do Girls Club of America or Planned Parenthood. You may dispute the churches. Some of us would dispute Planned Parenthood, but because the government has made the determination.
It's granted by IRS. Right.
Right.
That's who.
Right.
There's also property taxes, and the criteria are exactly as the professor suggests. There's I think it's called the North Star factors, where you look at whether it eases the burdens or helps people, and if it does, then it qualifies as an exempt from property taxes.
There's a state constitutional ban on property taxes of religious entities as well. So there's the state dimension.
Right.
But that's not true in all states.
That's not true in all states, though. But it is a political judgment, as
Right.
Professor Clint was saying. One study has shown that religious groups and entities provide over $60 billion in social capital to our economy every year through the services and ministries that they provide.
And I think that's a really important point to note, because people seem, even in my classroom yesterday when I was teaching Kilo, and there was, they put their great faith in constitutional interpretations instead of political judgments. And so even if the court were to disregard footnote 3 and to give the broadest impact of the case, the simple fact is that there's nothing to challenge unless you get it through the legislature or whatever legislative body you're dealing with, which is why the Colorado case is so interesting. They even had the law, even had the Colorado Supreme Court come back and said, yes, this county program of vouchers is constitutional. All you have to do is repeal it, and we're done. But it does leave it to the judgment of the current legislative bodies, as opposed to preempting that current judgment by a constitutional determination. So depending on how much you like direct democracy, constitutional change shouldn't be something you fear.
Here we go. Let's that one up.
So the non-discrimination argument in the individual case makes sense. So the question I had is kind of in the collective as you look at these programs, and is there ever an issue where we're setting up an argument where maybe certain churches benefit more than other institutions, especially if these programs are ever closed, like housing voucher programs sometimes close. Is there ever a point where we're going to have to step back then and look and see that, oh no, now we've benefited more Catholics or Presbyterian churches and not enough synagogues, and now we've established a religion by de facto. Is there a danger there that we're going to have to administer that somehow?
If I understand your question, and I may not, so forgive me if I'm not responsive, and I'll try again. But I'm aware of no other constitutional provision where we do a head count of who exercises it. So if we were to do that, then I would think most of the major media would have to be closed down or give us access. The fairness doctrine would be written in, because certainly their voices are much louder and exercised more often in the public square than mine or yours or other people. So I think that would be a very odd principle to engraft.
Difference being tax dollars. If we pay tax dollars to a particular number of churches, somebody comes along, the new church is maybe denied. That's the question is, are we ever going to have to look at it at macro as opposed to the individual church? Good thing, we step back and we look at the program and say, oh no, you've not equally applied this.
I think that would be a programmatic judgment rather than a head counting judgment, though, right? Which kind of raises, I thought, the question that the person who asked about textbooks raised. It is true that you can't buy catechisms for the classroom as a general rule, but the Supreme Court for a long period of time has said that we can study religion as a cultural question. And so if as a condition of understanding the Bible as literature or understanding Islamic culture, we need to buy copies of religious texts, that is legally permissible under the Establishment Clause. Many school boards would not make that judgment out of fear, again, back to the political point, but as I understand, that is legally permissible.
Yeah, I would hearken us back to what the court said back in Everson, which was states cannot exclude individual, and this is the micro level, Catholics, Lutherans, Mohammedans, Baptists, Jews, Methodists, non-believers, Presbyterians, or members of any other faith because of their faith or lack of it from receiving the benefits of public welfare legislation. Well, it seems like it applies equally to every group, and I would think that that principle would apply to this question.
I mean, I think to your point, the Supreme Court confronted this in the Zellman case, which had upheld the Cleveland voucher program. Most of the schools that students chose as a result of receiving that voucher ended up being Catholic schools. It was the fact that most of the non-public schools in the Cleveland area were, in fact, Catholic schools. The Supreme Court didn't say that that was an Establishment Clause problem. Similarly, if in Utah, for example, all the public welfare programs went to Mormon churches, or most of them, you would probably say, well, that's sort of a function of Utah, that most of the religious congregations are going to be LDS. But if you saw sort of systemic discrimination, then entities that were denied grant funding because, systematically, like let's say, 10 there was 10 grants, 6 of them went to LDS, 4 of them went to secular, and the Catholics all got excluded. Well, if that happened repeatedly, then you'd have a good equal protection claim argument in those contexts too. So it could be on a case-by-case thing that if there was actual evidence of animus or discrimination, you'd have a claim to litigate that in that specific grant funding context.
Right here. Right here.
Okay.
Back to this, just generally about the school choice programs, could you describe how, if there is a functioning school choice program and how it works, and then the current controversy about it?
School choice programs come in many different shapes and sizes. They're all designed to get around this Blaine Amendment challenge or problem, though, in the sense that none of them fund schools directly, right? So what they do is they create financial programs for parents to be able to then have the financial means to send their kids to non-public schools. So typically they apply to lower middle income families, and they come in 3 forms: tax credits, a voucher, or they create educational savings accounts, kind of like a debit card that the state gives you, and then you can use it for whatever educational option you want. Now, the only way that these programs aid a religious school is indirectly, not directly. States will say, well, this is still an aid of religion or an aid of a sectarian school. That's unconstitutional under the Blaine Amendment. Most states have rejected Blaine Amendment challenges when those have come up precisely because of this issue of indirect aid. The money funnels to parents who then make the choice. They could take that voucher, they could use their savings account on secular, non-public educational options. But the mechanism is a parent makes the choice for the child about where they go, and that could be a religious school. As someone who's litigated these cases and then now advocates for school choice programs, I think there's no constitutional issue. The U.S. Supreme Court has said so. The question is at the state level, what does that look like? Minnesota led the way in choice programs. We have deductions and some form of limited credits for low-income families. We don't really have a full-blown school choice program like in Milwaukee, Cleveland. Some states have Georgia, Indiana, Pennsylvania, Arizona would probably be the most active case in creating massive school choice programs for a wide variety of parents and families.
What about the idea of if the First Amendment Establishment Clause, it's going to be used to prevent discrimination? Well, what if the religious institution is a discriminator? So you've got two levels of discrimination going on. Isn't there some protection from 14th Amendment equal protection that would try to not want to advance by giving public money to a discriminatory organization, institution? Is there a clash there, a conflict?
The cases, certainly that argument has been made. That was the argument in part about surrounding hospital mergers, surrounding a lot of other areas. The problem with that is that what it suggests is, and it really doesn't arise as a general rule as far as admission, et cetera. So when we were talking about exceptions to the contraceptive mandate, for example, right? Many of the institutions, like St. Thomas, we accept students from all faiths. We accept students of all political persuasions. And so, but we ourselves, as the institutional personnel, as the institutional, we have preserved the right to prefer Catholics in our hiring practices, at least for faculty in certain limited instances. So, for example, we believe that the seminary should be largely populated by faculty who believe in the Roman Catholic Church and believe in our understanding of Christianity. I find it odd to believe that they would be denied FEMA relief simply on that basis. But again, it's an argument that's being made actively in the courts. And in part, all of these decisions are preceded by political judgments, right?
Hang on just a sec. Big talk. We're recording though for people. I got to remind you all that because
Here we
of
go.
replay capability.
We spoke last week about the media, and there's been a lot of scuttlebutt about what type of what qualifies as media and whether they deserve the First Amendment protections. And presumably, you could have every individual in the United States believing in their own religion, and what do we then call a religion? Do we involve government in saying, you're licensed to be a religion, we will call you a religion, but we won't call these people, and are there dangers, or what's the next step?
The Supreme Court has confronted that in many cases. So one of the ones that amuses me most is where a brothel in California tried to defend against criminal regulation because they were engaged in the ancient pagan worship of religion through sexual congress. And, very creative.
Don't forget the Church of Filet Mignon, right?
Oh, and there are actually
I did not know this.
published opinions
The Church of
where
Filet Mignon.
both of the same plaintiff, I would note, but where a prisoner asserted that he was a member of the Church of Filet Mignon, and therefore that required the prison to accommodate his religious beliefs by providing filet mignon and red wine on Sunday nights. So independent of whether people actually had their own unique individualistic religion, which was your hypothetical, the courts have long been in the business, as have various other government entities like the IRS, to figure out, is this something that should receive protection or should not? Generally, the courts are very cautious about ruling on religious doctrine per se, right? So the Church of the Infinite Spaghetti Monster, a reference made in actually case, right? By the same token, it's clearly fraudulent, at least the Church of Filet Mignon. And so there's a sincerity test that they add beyond that. And that's where, but some of the cases are really difficult. When I was teaching in Houston, we had a federal case where there were high school students who were wearing rosaries in the same way Madonna does. Now, a Catholic who's been well catechized knows that's not the way you carry your rosary. But nonetheless, a lot of Catholics don't know that. So there were high school students wearing rosaries, and the principal banned the wearing of rosaries in a public school. And the question became, you know, can he do this? And the principal's defense was this had been adopted by a gang. And it was in an area of town where there were tremendous problems with gang activity in high schools. And in the end, you know, do we admit evidence? It gets to the level of, do we admit evidence as to the church's teaching on the proper carrying of rosaries and use of rosaries? Typically, the courts won't get into that doctrinal, but sometimes, you know, like the Church of Filet Mignon, there are judgments that must be made.
Wow.
Which is a
You give a
non-answer.
prisoner a law library and look at what you come up with. It's unbelievable.
You're making me hungry.
I think it should be noted too, and to follow up to that question, is that oftentimes when people hear the word religious liberty, it's as though we're tolerating anything goes. You can believe any kooky thing and then receive an accommodation or a get out of jail free card for your activity. That's not at all the case. Liberty is different than license, right? And those folks who advocate for religious liberty are very comfortable with the constitutional test imposed by Minnesota courts, but also in language such as the Religious Freedom Restoration Act, which is federal law, but has been bubbling up in states and various controversies. But this should be a pretty common sense principle from my vantage point, is that absent, it doesn't matter what you believe, where the courts aren't going to get into the specific nature of your beliefs. But there's no point in burdening religious exercise unless there's a compelling governmental interest to do so. And the way in which that burden is tailored is to meet that interest in as narrow way as possible. So that the default setting should be that, look, we're going to let 1,000 flowers bloom. We're not going to get into people's religious ideas, religious doctrines. There's a premise or a presupposition that religion provides great value to a free society. It's necessary to preserve it. It builds that social capital, as Washington said and advised in his farewell address, and that we're not going to burden that absent some compelling interest. We don't need, for example, to get into the particulars of various doctrines or religious beliefs, but absent a compelling governmental interest to do so, one could say you want to prevent the anti-discrimination piece. That could be a compelling interest. Now, people have different ideas about what compelling interest should burden religious exercise, but I think that's a rule that generally fosters a healthy pluralism around these discussions and gets rid of some of the most excessive things that people are concerned about.
Yes, sir.
I have a question that seems to kind of bring up attention on maybe perhaps two First Amendment claims. In downtown Minneapolis, there was an owner of an adult entertainment establishment who wanted to expand it to be even a more adult entertainment. And there's a church that has a gathering place in not a church building, but in a commercial building within 500 feet of that establishment. And the Minneapolis City Council is refusing to grant a license to that nightclub owner to expand his business because there's a 500-foot exemption for churches. And to me, that seems like a conflict between establishment. Why does a church get to have a 500-foot exemption and a bakery doesn't, or a dry cleaner doesn't? And the nightclub owner is not doing anything illegal. It's certainly free expression under the First Amendment. Who makes the decision here? Who makes the call?
I think it's more than just it's schools too. There's some other groups specified for that 500-foot radius as well as churches, but thoughts about that?
Land use regulation has always been a complex area. And initially, in fact, it was a constitutional question whether you could burden land ownership with regulation at all. Now, ultimately, the Supreme Court came down and said, yes, you can. But then the question becomes, when does it either constitute a taking, or when it clashes with other interests, other constitutional interests? And so cases vary on that. And I would suggest that it's, in part, the courts have upheld those sorts of, you can't place a bar near an elementary school or right next to a church. You can't place a number of other things. It's not simply adult entertainment, and I've always wondered why they called it adult, but that's a separate issue.
Hopeful.
And yeah, I agree. So I think a lot of times that will turn on how broad the exemption is. Does it cover churches? Does it cover schools? Does it cover healthcare institutions, recovery houses sometimes, et cetera? And then also the distance that it regulates. And I think part of that is just the balancing when you have competing constitutional interests.
And it's important to note, too, that they're not regulating speech in that instance. What the regulation is, the secondary effects of these entities, the spillover from the well-known problems that are associated with bars, strip clubs, et cetera, et cetera. So not regulating the speech, it's the effects, the well-known effects that these things have. And what's important to note is that some of these questions are political judgments, and not everything has to happen in the courts, right? Sometimes the political process is a good way to adjudicate some of these difficult questions and some of these disputes between religion and the state, or secular values, et cetera, et cetera. This was what I think Justice Scalia hoped for in the Employment Division versus Smith case, is that, generally applicable laws would apply to everyone, and if people needed an exemption or an accommodation because of religious practice, they could go to a legislature and get that exemption. But we're not going to grant broad latitude to the Church of Filet Mignon or Native American peyote smokers, et cetera, et cetera. I think he was wrong in that decision, and I think the effects of that now are being felt because we're having a lot of these difficult tensions, and the political process is not necessarily the best place to adjudicate those all the time. But it can be and should be, and we shouldn't always necessarily think that courts are the best way to adjudicate some of these really challenging questions and divisions that we have on some of these issues.
Do you think we're going to see this case or this decision by the city council make its way through the courts? Any over-under on that?
Cities on
Well,
good standing.
I practiced private practice in the zoning area, and it is a hot topic. The cases do vary. Anybody remember Ferris Alexander? He had a bunch of cases, and he had a lawyer, Randall Teague, who was always taking those cases up on appeal in terms of whether or not he had the constitutional right under the First Amendment to do this or do that. So I'm not going to weigh into it, but I am going to tell you a story because it's kind of fun. We represented Hirschfield's. They owned property right next to Cafe de Napoli, and they were pining to sell that property for a long time. And all of a sudden, one day, they got a cash offer on that property, and they were very excited until they realized that the purchaser was a Ferris Alexander entity. And so there was a lot of discussion about First Amendment rights and this and that, and having that property right next to Cafe de Napoli, and there was a friendship between the owners of both, and they were both sort of distraught. And then the legal beagle lawyers, my firm, looked at it and said, well, gee, there's a shared parking agreement. We can't sell the property unless we get consent of Cafe de Napoli. So we're going to, before we sign this agreement, we're going to ask them for consent, which of course they didn't give. And then there was a lawsuit for specific performance, and it went all the way up to the Supreme Court, and the Hirschfield position prevailed. And so you have them to thank for not having buns and roses right next to what used to be Cafe de Napoli downtown Minneapolis.
Here we go. Yes, sir.
Yeah, I'd like to go back to the vouchers. If I remember right, you mentioned the case where there was the gentleman who wanted to go to a seminary of some sort and applied for a scholarship, and it was decided, no, you can't
Yeah, Locke
do
and
that.
Devi,
Right.
right.
How does that situation differ from vouchers and the parents who were expecting that voucher with the intent that they're going to send their child to a sectarian school?
The difference is that Josh Davy in that case was studying to be a minister. He could have studied theology or religion using that scholarship, but he couldn't be a minister, and that would be the distinction. So kids receiving aid to go to non-public parochial schools might have religious education, but they're not studying for seminary in that context. That would be the distinction.
Okay, thank you.
Yeah, it gets back to, I think, what they said in Trinity Lutheran. There's a difference between being discriminated against because you're a church versus being discriminated against what you want to do, become a minister.
And I'd kind of like to highlight one of the points of your story, Justice Dietzen, also. And I would hope in a room full of lawyers that it would not be the same. But so often when I do public speeches, I just did a debate for the League of Women Voters on Constitutional Convention last week, or this week. It's Friday. And there are so many people that forget the constitutional provisions are about restraining government action. They're not about restraining individual actions. There's only one portion of the Constitution that applies to individual actions, and that's the 13th Amendment. You can't own a slave, whether you're a government entity or not. But beyond that, the rest of it, so private agreements like the parking agreement and the fallout of the parking agreement, or private donations, et cetera, simply aren't subject to constitutional provisions. They are subject to statutory provisions, but they're not subject to constitutional provisions. And sometimes we forget that. Everything seems to get constitutionalized, when in fact, the Constitution as drafted at the federal level was intended to be fairly narrow in scope.
Let's go to the last question back there, and then we'll have a little time to sum up.
Hi, I actually was curious about financial transparency, and correct me if I'm wrong, I'm not a law student or a law professional or anything like that, but as I was aware of it, that houses of worship are allowed to be a little bit more financially opaque, I guess, and just wondering if you could comment on why that is, or if you think that kind of breeds any sort of sense of corruption of any kind, or just kind of to elaborate on that.
Might be a little bit out of the area of the conversation
Every
and
nonprofit
expertise, but
files a 990 in order to maintain their tax status. And in fact, one of the things I do when I'm thinking about giving to a charity is I look at their 990s, and they're available online, not the most current one typically, but if you go to GuideStar, it will let you look at where money goes, so you can see this is a charity that receives $1 million a year in funding, and their executive director makes $800,000. I'll send you the job application. That's not a charity I'm interested in giving my money to, right? And so I'm not sure. I think I'd push back a little bit on churches being particularly opaque on that point.
Yeah, I think I was going to make the same sort of point. The nonprofits are filing at the state and federal level, and then even if they want to become tax exempt for under 501c3, they have to file all kinds of information regarding the entity and what they do. If they want to become property tax exempt, they have to file property and loss statements and show how the money is used to further their mission, to make sure that the members aren't being privately benefited. So I'm not so sure. I mean, I certainly think that it's probably true that the case law is moving in a different direction in terms of the Lemon v. Kurtzman was you have to document that every dollar is not using to further religion, and we're moving away from that, and we're moving, I mean, the case law is moving away, and so that's certainly true. But that has been on the court's constitutional interpretations.
Let's just take a minute and have some final comments on this particular topic and what we've discussed today. Anything that you want to emphasize or that you feel like's left out, Professor?
So a number of years ago, the American Bar Association asked me to write a short article in a debate format over vouchers. And this was when I was still down in Texas, so it was more than 15 years ago. The status of the law was not what it is today. But one of the things I discovered in writing that article is that particularly in large urban areas, often the best or the most successful as based on test scores educators in the inner city are not public schools. They are, in fact, schools that have some religious affiliation. They have a higher graduation rate, they have a higher test scores, there are a number of things. Now, we can debate why that is, and often in the debate the argument is made, well, if you're a private school, you can exclude students that are more problematic students, or you can you don't have to provide all of the benefits that public schools do for handicapped or children that don't have English as their first language. But I think that's one of the things that makes this debate so intense, is that there is substantial empirical evidence that for the underserved, for those who arrive in this country with an incapacity to speak English, at least initially, religiously affiliated schools have been often the greatest educators, and that hasn't changed from the days when the nuns all wore long black habits and used rulers liberally. It is as true today in downtown Detroit as it was back then. And so it's an odd thing to believe that the Constitution constrains us from using those resources to benefit the most vulnerable in our society. And I'm optimistic by this new Supreme Court trend.
Justice.
Yes. Well, I found preparing for this to be a really wonderful exercise for me, because when I went to law school, Lemon v. Kurtzman was the holy grail, and that's how things were functioning. And from my vantage point, the law has changed considerably, and just reading the Trinity Lutheran case was really very helpful. At the Minnesota Supreme Court, we rarely get cases involving separation of church-state. The Hershberger case is probably my most favorite. We certainly have had cases involving clergy, the Wenthe case, but nothing like we're talking about. That's really grounded in First Amendment stuff. And you look at these cases and they talk about the founding debate was on whether or not the government should be required or should fund paying the training or paying for clergy and paying to build church buildings. We are in a whole different world than that. We're talking about, applying religiously neutral criteria to things like, public welfare legislation and benefits. And today, in today's world, public welfare benefits fill a really broad category of stuff. And I think that the government is becoming increasingly more involved in our lives, whether we want it to or not. And so this sort of trend is going to be very interesting to see where it goes, where Trinity Lutheran takes us. So, but it still comes down to those two competing principles that we talked about at the very beginning. It's those two sentences in Everson that the court's trying to work out how you balance those, those two competing principles.
And I would just add briefly on that. I think that's right in the sense that what constitutes neutrality now. I mean, I think that's a touchstone constitutional principle is neutrality toward government, neutrality toward religion. But in this changing dynamic, as Justice Dietzens described, where government does so many more things with dollars. Does neutrality mean exclusion, or does neutrality mean equal access? And I think from the Trinity Lutheran case, you've got a really strong majority that looks at that as equal access and not exclusion, not allowing those state anti-establishment principles to continue to exclude religious groups from participation in public funding programs.
Fantastic. What a great program. Thank you for being here on Good Friday, soon to be Passover, and I better not forget anybody else on this day. Keep it theme, but thank you all for being here. Let's give them a hand.